Welcome back for our final panel of the day. I'm pleased to welcome our next moderator, Justice Kenny Griffis of the Supreme Court of Mississippi. Justice Griffis was appointed to the Supreme Court of Mississippi in 2019 and was elected to a full term in 2022. Justice Griffis previously served on the Court of Appeals for Mississippi for 16 years and ended his tenure there as its chief judge. Justice Griffis regularly serves as an adjunct professor at the Mississippi College School of Law and the University of Mississippi School of Law. He has earned his degrees in accounting and law at the University of Mississippi. And with that, I will turn it over to Justice Griffis to introduce his panel.
Thank you very much. Thank you all. I want to say my thanks to Donald and the Law and Economics Center. This being the 16th anniversary or 16th annual symposium, I think I've now been to about 13 of them, so I appreciate what you do and the opportunity we have to come and get a little judicial education, so thank you. Third-party litigation financing. In my state, I never really thought that we had it. I don't know if that's good or not. I never really thought about it anything other than my banker wanted to make sure that I settled my cases on time to pay my banker back. But I really have two financial regrets in my life. One is that I had a chance to buy John Grisham's first book, A Time to Kill, a first edition for $18. I turned that down. It's worth over $5,000 today. A second regret I have is that I was sitting eating lunch with about 5 of my friends one day, lawyers, and we were talking about the various opportunities of the day. And one of them just mentioned that they had a meeting with Dickie Scruggs and Mike Moore, and they had agreed to put in $100,000 for what has now become known as the tobacco litigation. Two of the colleagues with us had indicated that they had already turned them down, that they thought it was a waste of money. And they asked me what I thought about it. And the lawyer that did it told me that he could get me an audience with Dickie and Mike that afternoon if I was willing to. I declined. That's why I'm here now. But I really enjoy this topic, and I've learned a lot about it. And I think that there are a lot of concerns that still have not been ferreted out, but I do believe we have an excellent panel here today. So let me briefly introduce them to you. Andrew Cohen is a director of Burford Capital, LLC. He underwrites legal risk and monitors policy and regulatory issues in the legal finance industry. Burford Capital advertises as the leading finance firm focused on the law, and it's listed in the New York Stock Exchange and the London Stock Exchange. Burford helps companies and law firms optimize the value of their legal assets. He's a graduate of Columbia Law School, and he's going to discuss the evolution of legal finance, the state of the industry post-COVID, and how it works in practice. Tripp Haston is a partner with the Bradley Arant Boult Cummings firm in Birmingham, Alabama, and he chairs the firm's life sciences litigation team. He serves on several regional and national counsel companies in complex individual and mass tort litigation. Oddly, Tripp is a graduate of both Auburn and Alabama, although I'd be willing to bet he would say War Eagle.
War Eagle.
Sure. Tripp will discuss the background and evolution of the industry from Australia, Europe, and U.S., and its regulation and oversight. Jordan Schwartz is a partner with the Washington, D.C. firm of Skadden Arps. He represents clients in mass torts, insurance, and consumer litigation, and is a graduate of the George Washington Law School. Jordan will address us on the importance of disclosure and the various ways courts can require disclosure of this topic. Professor Meyer Steinitz, I hope I pronounced that, that's as good as an old Mississippi redneck can do, is a distinguished professor of law at the University of Iowa. She teaches civil procedure, corporations, international business transactions, and international arbitration. She's one of the nation's leading experts on litigation finance. She's a graduate of New York University Law School, and she will discuss how litigation funding is morphing into law firm finance and focus on Arizona's reform, which abolished the fee-sharing prohibition and now allows non-lawyer ownership in law firms. And with that, I'll turn it over to Andrew.
Thanks so much. And I want to thank the organizers for inviting me. There have been some really interesting panels today, which I've really enjoyed listening to. I want to start talking about what is legal finance beyond what Justice Griffis described. To be clear, my experience at Burford Capital is about commercial litigation finance, and so I'm going to be talking primarily about that and not quite as much about the consumer litigation finance side of things where you might see investing in mass torts or PI litigation. I'm talking about the evolution of litigation finance. So when we started, we were really talking about single case financing. And that's sort of what you think of when you think of litigation finance. It's where a litigant doesn't have enough resources to pursue a case, or they could pursue the case, but not with the counsel they think they need in order to pursue it as well as they should. And maybe they don't have those resources because of the harm they've experienced. But they know that they've got a good case to bring. And so their options are they can resolve it early or before really litigating it, and that would be probably less of a value than they would want to, or they can get that litigation financed through some third party. Traditionally, that was you could go to a bank, but now that there's the existence of specialty finance providers like Burford, those kind of folks have more options. And there's important characteristics of commercial litigation finance. The first one that we stress over and over again is that commercial litigation finance is non-recourse. That means that the funder's payment is contingent on the outcome of the specific litigation. And that means that the funder is taking on the risk of loss on the case, as well as the risk that the case doesn't do as well as everyone was hoping. That also means, as a consequence, that funders do extensive diligence in order to understand the risks of the litigation we're investing in. One side effect of this diligence that we do that we like to stress is that we actually serve as a screening function on litigation. Marginal cases are less likely to obtain funding because we don't want to lose our money in investing in a bad case. And so that means that if those marginal cases don't go forward, that's actually a benefit to the overall civil justice system. The second characteristic of commercial litigation finance that I want to talk about is we do not involve a transfer of control from the litigant to the funder. Litigation funders want to be passive investors, not active litigants. We don't control litigation strategy or settlement. That is clear in our documents. And just to be clear, we do talk to our clients about the litigation that's going on, and we often talk about strategy. They're obviously obligated to keep us informed about the cases that we were invested in. And most of our clients want to hear what we have to think about the cases because we are serial litigators. We're involved. That is what we do. We can provide a separate point of view from their own counsel. But whatever we think, our documents are clear that the settlement authority rests with the clients. So then you might ask, how do we manage that lack of control? Why are we just sending money at something we don't control? And the answer is we structure our deal terms to reflect the risks of the case so that we try to keep the incentives properly aligned. That means that there might be some time-based return element or one that increases when key things happen in the case, like summary judgment or trial. And that's in order to make sure that our counterparties understand our funding is not a free option. They can't just pursue the case to the end of the earth. They have to make the economic decision based on the funding they've taken, whether it makes sense rationally to settle at a point that is, before summary judgment or to take it forward. But whatever they decide, we're sort of going along with them for the ride. Starting from single case investments, we found over time it was more efficient to pivot to sort of law firm finance and law firm portfolios. And these are law firms that have matters on contingency or who are looking to build a contingency book or new practice group, but they want to limit their own capital outlay. And so our funding in those cases is more about out-of-pocket expenses or we'll pay partial hourly rates in advance. Again, non-recourse, the funder does not have control. And with law firms, the idea of funder control is even sort of more absurd because lawyers don't control the litigations they're working on under Model Rule 1.2. And candidly, though we still are happy to talk to lawyers about strategy, most lawyers we work with are happy to take their own advice and not listen to us, although some still do hear what we have to say. And why do we pivot to portfolios? The answer is there are transaction costs that are the same whether we do a single $2 million deal or $20 million deal, and negotiating documents on 20 smaller deals is 20 times longer than negotiating one big document. So there's also a cost savings to the client because if we do a portfolio deal, if it's a cross-collateralized portfolio, lots of different litigation, our overall risk is reduced, and so the cost of funding to the client is reduced. And from our side, even though the returns are lower because the costs are lower to the client, there tends to be sort of a more steady cash flow as multiple cases resolve over time. While our portfolio deals started with law firms, they then sort of pivoted to corporate deals. When we started, we were looking at smaller and medium-sized companies that wouldn't really have enough litigation to have a portfolio. But as time went on, we started to talk to larger Fortune 100, Fortune 50 companies that already had an active recovery program in place where they're actually doing affirmative litigation on their own behalf, or they wanted to set up a program but didn't want to have a capital outlay that would hit their bottom line. So financing those costs, even for a company that has the money to pay for it themselves, makes sense to those kind of companies for accounting and tax reasons. And at the same time, we saw a growing interest in monetization of corporate claims among those kind of companies. And so for a number of reasons, whether maybe they needed to cash in a particular year, or maybe they're looking for certainty in cash flows over time, they would finance a portion of the expected proceeds of that litigation. Again, non-recourse and no transfer of control. They simply are selling off a portion of the proceeds of the expected proceeds of litigation. So where are we today? We have a robust commercial finance industry used by small, medium, large companies and law firms to address a variety of needs. They might have lack of capital, they might have excess risk they didn't want to offset, but now it can also be a form of cash management for those companies that are simply monetizing. Our counterparties are typically sophisticated companies and law firms, and they're independently represented during the course of our negotiation and over the course of the funding transaction. There's a broad range of funders out there. There's small, medium, and large, and we focus on different kinds of litigation, different funding structures, different transaction sizes. So there is a broad variety of funding out there. Our capital sources are typically private capital, other than a couple of publicly traded companies like Burford. And I think it's important to keep in mind that the entire litigation funding industry is really still just a drop in the bucket of the overall legal market, no matter how you define it. We're involved in a relatively small number of cases compared to the hundreds of thousands of litigations that are happening nationwide. And the total capital outlay, even if it's measured in billions of dollars over all funders in the US, it's still a small fraction of the several hundred billions of dollars of the legal market. I want to talk a little bit about regulation. Where do we sit? And the answer is we sit in a broadly applicable regulatory scheme. That includes court supervision of the litigations we invest in, state contract law and other state law that just sort of regulates general business, and state and federal investor protection laws when we're raising our capital. And there are calls for special regulation that applies to litigation funding. And I think it's important to think about the motivation for that special regulation in context. I just want to talk a little bit about disclosure. I know we're going to get there. My experience with disclosure is that, as a general rule, in the litigations we invest, the fact of our investment is not relevant to the merits of the case unless it's actually an element of the claims or defenses in the litigation. Most courts in the US, in my experience, do not allow discovery into private parties' private finances, let alone require automatic disclosure of that information. And in most of our investments, there is no automatic disclosure of the fact or details of funding. When our clients are required to disclose, and whether that's a specific disclosure rule like the District of New Jersey enacted last year, or a more general rule like in the Northern District of California that's broad enough to cover some of the types of investments we do, those clients disclose the fact of funding. And that sometimes leads to discovery sideshows or delay or increased costs. And that's because, in addition to being irrelevant, courts have nearly unanimously held that litigation funding documents are protected work product. We're usually talking about one of two types of documents. The first is documents the client shared with a funder during the diligence process, and if those were protected before, they're not protected because they were disclosed to a funder who is not likely to disclose those to an adverse party. The second type of documents is the deal documents themselves, and most courts have found that these agreements are also protected work product because the terms reflect the mental impressions of litigation attorneys that were disclosed during the course of diligence. And sometimes courts will take those documents in camera and review them to verify that. And when that happens, they typically reach the same conclusion. Perhaps they'll order a redacted disclosure of those deal documents, but not the key financial terms that reflect the structuring that we did to make sure incentives were in line, that it reflects the key mental impressions. I know I'm going over my time, so I will leave off the discussion of the District of New Jersey rule until there's discussion. I just want to say overall, commercial legal finance has certainly grown over the past decade. It's become more professionalized, and we now have an industry group, the International Legal Finance Association, which represents the major players in the industry, and it promulgates best practices for commercial legal finance. And over time, as the legal industry shifts, the legal funding industry will continue to evolve to meet the issues that arise. Thanks.
Tripp?
Thanks, Justice. Tripp Haston from Bradley, Arant, Birmingham, Alabama. It's a real pleasure to be here. I want to thank Don for inviting me. It's a particular pleasure because I know I have some of my judges from Birmingham here today, and I also got to see one of my old classmates, Justice Kelvin Terry here, who I hadn't seen since we got out of law school. So this is really a pleasure to talk with you today. And it's a particular pleasure to talk with you today about what I believe to be the #1 topic in civil litigation today. It's the most serious, it's the most structural, yet it's also the most stealth issue in litigation. I'll start with this question. How many of you have had to encounter, deal with, discover anything about third-party litigation in any of your cases? So I see a few hands, but most of you haven't, so I'm glad we're able to sort of raise awareness about third-party litigation and what little we know about it. The reason I think so few hands are up in the room is because there is really no uniform disclosure of third-party litigation funding happening in individual cases. It's an industry, as you've heard about from Andrew, that gives non-parties to a lawsuit cash in exchange for some share in the outcome of that case, based on several instances in which we have seen funding agreements, and there's a lot of opposition to sharing that type of information. We know that often funders have some say, some control, some input into what actually happens in a case. The idea that a reasonably intelligent financial entity would just hand some money over after due diligence and walk away and say, call me when it comes out, it's just sort of hard to sort of believe that's what's actually happening. We have little data about what is actually happening, again, because there is no disclosure. And we're not talking about small dollars here. Although it's impossible to measure the precise dollar amount invested every year in U.S. litigation, estimates range from anywhere from $5 billion to $11 billion. While they act as financiers in civil litigation, their operations are not governed by any of our nation's financial regulators. And while they fuel and affect litigation in significant ways, they're not governed by any state or federal agency with regard to their operations. And while the vast majority of everyone in this room and every significant actor in a courtroom is bound to honor a binding and enforceable ethical code as a bedrock foundation for our profession, TPLF members are free of any such constraints in this country. And it's not just me saying it, but in Burford Capital's annual report from this past year, they say this: there is no federal regulation of litigation finance in the U.S. Individual states or individual judicial districts may promulgate rules concerning matters such as disclosure, but there's no widespread or national trend in connection therewith. In our country's history, when other branches of government fail in their oversight or enforcement of laws, it always falls on the shoulders of the judiciary to lead. That's precisely where we find ourselves today, and I hope the panel's discussion today will illuminate the existence of and importance of that role of the judiciary when it comes to TPLF. In addition to my time at Bradley Arant, where I've represented individuals and businesses, often in mass tort litigation, I'm also the past president of an international legal organization called the International Association of Defense Counsel, the IADC. It's kind of a mouthful. But that organization, we have members from over 40 countries around the world, and what we do is represent business and insurance interest in disputes litigation. Litigation here, usually arbitration abroad. And in my personal practice and leadership roles with the other organizations, I've become acquainted with TPLF And this general awareness spans not only domestic issues here, but globally due to that engagement with the IADC. My remarks today will focus on 3 topics: the birth and spread of TPLF from abroad to our shores; second, TPLF regulation abroad and the effort to regulate it here; and third, reasons why ordering routine disclosure of TPLF involvement in individual cases or coordinated proceedings is important. So TPLF was born in Australia, and then it migrated more than 20 years ago from there into the UK and Europe. It grew rapidly there due to its appeal to access to justice in these markets, which possess 3 distinct attributes that we don't have in the United States. They're mainly loser pay systems, where if you lose the case, you have to reimburse the other party for costs and fees. Second, contingency fee arrangements are largely prohibited, unlike here in the United States. And the major sort of threat and weapon in civil litigation today, punitive damages, are unheard of. After its success abroad, it arrived in the U.S. more than 10 years ago and has become widespread. The U.S. now serves as the largest global market due to the fact that we are simply more litigious in our country than any other place in the world. So it's a huge market. Today, the members include numerous multi-billion-dollar organizations publicly traded on the U.S. and foreign stock exchanges, which we know a bit about because of their public filings. But there are also numerous privately held organizations about which we know very little. Though we're prideful of our legal system here, as we should be, when it comes to oversight of TPLF, we're far behind the rest of the world. This is due in part to the relatively recent arrival here, but more broadly to the success TPLF members have fought off when it comes to oversight and disclosure of their operations. In nearly every foreign market in which they operate, TPLF members are subject to some standard uniform regulation. For example, in Australia and New Zealand, they require litigants to routinely disclose TPLF involvement and certain elements of funding agreements in class action matters and often in other types of civil litigation. In Hong Kong and Singapore, TPLF is largely prohibited in civil litigation with limited exceptions, but it's flourished in private arbitration proceedings. However, the Hong Kong and Singapore arbitrable bodies have substantial codes governing practices of TPLF and require routine disclosure of its involvement. In the UK, TPLF members are regulated by the Financial Control Authority, and courts have the inherent power to compel disclosure of a funder's involvement. In Canada, several provinces routinely require TPLF arrangements to be disclosed and judicially approved in class action cases and often in other non-class cases as well. And in the EU, the most substantial step toward broad oversight and routine disclosure occurred just last month when the European Parliament adopted comprehensive legislation that now goes to the European Commission for implementation. Yet in the U.S., oversight of the industry is nascent, it's ad hoc, and it's inconsistent. There are a few significant jurisdictions that are leading the trend toward routine disclosure in litigation, however. These include the U.S. District Courts of New Jersey, Delaware, and the Northern District of California. There are also a number of efforts underway with rules committees in Congress to address this vacuum of oversight. Just last month, the U.S. Government Accountability Office convened an expert roundtable on the subject of information availability concerning TPLF in this country. Professor Steinitz and myself and others were honored to serve on that roundtable. The upshot of our discussion, there's very limited, reliable information about TPLF's operations and effects in the U.S. due to the absence of routine disclosure. And why, might you ask, is routine disclosure of TPLF involvement in civil litigation here good public policy? Well, briefly, there are at least 3 compelling reasons: conflicts, control, and proportionality. For conflicts, for fundamental ethical reasons, it's important for all courts to know who is in their courtroom with a stake in and possibly control of a given litigation. We have a long history of requiring disclosure of potentially relevant parties for conflict purposes under Federal Rule 7.1 and state law equivalents to ensure judges are free from conflicts and avoid the appearance of impropriety. Chief Justice Roberts highlighted the importance of this very issue in his 2021 report on the federal judiciary and called for on the judiciary to double down on their efforts to avoid conflicts. Moreover, we know that foreign government-owned and controlled sovereign wealth funds are now investing in U.S. litigation through TPLF members. Former federal district judge and former U.S. Attorney General Michael Mukasey highlighted this national security risk in a recent Wall Street Journal editorial, noting that these foreign investors are funding substantial patent litigation in our country. The second reason to order routine disclosure is control. There are both ethical and practical reasons concerning control. In many U.S. jurisdictions, the laws of champerty and maintenance prohibit an unrelated third party from financing and controlling a litigation in return for a share of the litigation's proceeds. Without routine disclosure, such unethical acts would go unnoticed or prosecuted. And from a practical standpoint, we have a long history in this country of requiring routine disclosure of potentially relevant parties for ultimate resolution purposes. Federal Rule 26A1(4) and state law equivalents require disclosure of insurance agreements. When it comes time to potentially mediate or resolve a given matter, it benefits the court and all parties to know who is in the room and who has a say in the resolution of a given matter. Finally, the third reason to order routine disclosure is proportionality. In crafting fair and equitable discovery and to determine who should bear those costs, Federal Rule 26B1 and its state law equivalents require consideration of each party's resources in striking that balance. The discovery costs in litigation today are enormous, particularly in large MDLs. TPLF's involvement in funding mass tort litigation in the widespread advertising and filing of claims should not stop at the clerk's office where the cases are filed. If such litigations are being funded by TPLF, it's fair that the party receiving that funding benefit should also share the cost burden of discovery in the proceeding as well. Thanks again for the opportunity to address you about this important topic, and I look forward to our discussion.
Thank you, Tripp. Jordan?
Thank you, and good afternoon. By way of background, I work in the mass torts arena and do a lot of consumer class action litigation for defendants. I've also studied third-party litigation funding for a number of years, and as part of that work, I've had the pleasure of representing the U.S. Chamber of Commerce, which has advocated basic disclosure requirements for litigation funding. This afternoon, I want to talk concretely about the various reasons why litigation funding agreements should be disclosed as a matter of course in civil litigation. The first is that disclosure is necessary to prevent conflicts of interest, as Tripp mentioned. Unless the identity of a funder is disclosed, a judge could unwittingly sit in judgment of a case in which he or she has a financial or personal relationship, personal interest. This problem came to a head in a racketeering lawsuit that arose out of a Burford-backed class action against Chevron in Ecuador. During a deposition in the case, the lead plaintiff's lawyer was ordered to reveal the company that had funded the underlying litigation against Chevron. After it was revealed that Burford was the company that was funding the underlying litigation, the special master in the case made several disclosures of his own. The special master disclosed that he had previously served as co-counsel with the founder of Burford in a case. He had disclosed that he had received a Burford brochure for funding one of its cases, and the special master disclosed that he was personal friends with the former general counsel of Burford. Now, the special master didn't recuse himself in the case, and the parties didn't insist that he do so. But he said that the deposition demonstrated why it was, quote, imperative that lawyers disclose who the investors in their litigation are. Disclosure would also help enforce Model Rule of Professional Responsibility 5.4. That's the rule that says lawyers can't share fees with non-lawyers. And as Professor Steinitz talks about in her recent article, We have seen increasingly law firms partner up with litigation funders, entering into direct agreements, and there is a risk of violations of 5.4, and hopefully we'll talk a little bit about, what can we do outside of disclosure, but disclosure will help enforce that rule, which is the law in virtually every jurisdiction with the exception of Arizona. Disclosure is also necessary, as Tripp mentioned, to ensure that a plaintiff has control over her litigation. Logically, a funder is going to try to protect its investment by exerting some control over the litigation. The funding industry has repeatedly said, and we've heard it today, that funders don't exercise control over their litigation, but they have yet to come forward with any proof to back that up. And that's because doing so would require producing the agreements that they would continue to keep secret. The reality is that the agreements that have come to light as a result of a dispute between a funder and a law firm belie the narrative that we are hearing. The Burford-backed class action that I alluded to just a few minutes ago is a prime example. In the agreement in that case, Burford was given substantial control over the selection of counsel. If that is not a form of control, I don't know what is. Disclosure will also help enforce laws against champerty and maintenance. These are the centuries-old doctrines that basically said you can't buy and sell lawsuits. Now, the funding industry has promoted the view that these doctrines have been abolished across the country. They have been abolished in some jurisdictions, but they also are alive and well in others. And just a few years ago, the Sixth Circuit, the U.S. Court of Appeals for the Sixth Circuit, invalidated a series of litigation funding agreements on champerty grounds, on usury grounds as well, applying Kentucky law. Disclosure of litigation funding agreements is also necessary for class certification. In any class action, the plaintiff has to demonstrate that she and class counsel will fairly and adequately represent the interests of the class. If you have a funding agreement that vests authority or control in the hands of an outside funder, that is relevant. We have several courts that have basically recognized that third-party litigation funding is highly relevant to class actions. And I know that we heard that some courts have found that litigation funding is not relevant to the underlying claims or defenses. Putting that aside, I mean, it's certainly relevant to class certification, and we can talk about the various other types of claims beyond just the policy reasons why litigation funding should be disclosed. Disclosure is also important for fundamental fairness. A defendant has a right to know who its accuser is. When a third-party funder buys an interest in the outcome of a case, it essentially becomes a real party in interest that is adverse to the defendant, and the defendant should have a legitimate right to know that fact. Disclosure is also necessary for settlement. An executive of a prominent funder several years ago was quoted as saying, "Litigation funding makes it harder and more expensive to settle. Realistically, a defendant's settlement offer has to be sufficiently generous to provide the plaintiff with enough of a recovery after paying off not only the funder, but also the lawyer." Some years ago, the federal rules of civil procedure were amended to require defendants to produce insurance agreements to help calibrate settlement discussions, to help inform settlement discussions. The same rationale supports the disclosure of litigation funding agreements. And as Tripp mentioned, disclosure will also facilitate decisions regarding discovery and cost shifting. In the federal system and in most states, discovery has to be proportional to the needs of a case. And one of the requirements that courts are supposed to consider is the party's resources. And since it is the funder's resources that is making the underlying litigation possible, it should be considered part of the party's resources. And disclosure will also shine much needed light on potential national security risks. Although the precise extent of foreign investment in U.S. litigation is unclear, we know that it is happening. We know that foreign sovereign wealth funds are getting involved, and there is a risk that foreign actors, including potential adversaries, could seek to exploit the secret litigation funding system to harm U.S. companies, drain resources, and help home industries and gain a strategic advantage. As Tripp mentioned, former Attorney General Michael Mukasey recently highlighted these concerns in a Wall Street Journal op-ed. In that piece, Mr. Mukasey estimates that nearly a quarter of all U.S. patent cases are financed by litigation funding. And he goes on to explain that the overwhelming majority of the patent cases are not brought to help consumers. They're not brought to help inventors. Instead, they are brought to enrich investors with the added consequence of draining U.S. companies. These are the companies that the recent semiconductor bill last month or 2 months ago in Congress was designed to help bolster, to help our national security so that they could spend time developing technologies to make the United States safer. The article highlights ongoing litigation against U.S. Semiconductor Intel Corp., which last year was ordered to pay over $2 billion to a plaintiff shell company. The company is owned by a web of sovereign wealth funds. It doesn't invent anything. It doesn't manufacture anything. It exists for one reason: to acquire patents and sue U.S. companies. So to recap, there are a host of ethical, normative, and public policy reasons that support the disclosure of funding agreements. There are several pending proposals at the federal level and at the state level. In Congress, there is a bill called the Litigation Funding Transparency Act that would require the disclosure of funding agreements in class actions and multi-district litigation. The Federal Advisory Committee on Civil Rules is considering an amendment to Rule 26 that would go further. It would require funding agreements be disclosed in all civil litigation. And various states are also considering disclosure proposals, such as Ohio, at least in the context of consumer litigation funding. It remains to be seen whether and when any of these proposals will come to fruition. As a result, it's critical that courts, that judges employ their own tools and resources to bring about greater transparency around the practice. One simple and straightforward way to do that is to enter a standing order in all cases. That is the approach that Chief Judge Connolly, who's overseeing that litigation against Intel, that's what he did several months ago. And if you look at that standing order, it's very simple. It doesn't require production of the funding agreement itself, which I don't think is ideal, but it is a good positive step in the right direction. The standing order, which is one of the, I think, items on the list of suggested readings, would require the disclosure of the identity of the funder, whether the funder has any decision-making authority with respect to litigation or settlement decisions, a brief description of the nature of the financial interest, and the order does leave open the possibility of discovery, such as production of the agreement. This is an important and positive step. I don't think it's an adequate substitute for producing the agreement itself, because I think it's critical to actually see the agreement and the terms of the agreement to fairly and fully evaluate the potential risks that I mentioned earlier, including control, adequacy. How can you really fully evaluate whether a named plaintiff is going to be able to adequately represent the class if there is a third party who may have influence or decision-making authority? Another way judges could, this is a more modest way, create more transparency over litigation funding, is to raise the subject during pretrial conferences, such as those that happen under Federal Rule 16. Doing this would simply help bring litigation funding out from the shadows and help encourage candid discussions about the practice and what, if any, litigation funding is having on a particular case. And so while I'm hopeful that the pending legislative and rulemaking proposals will ultimately succeed, courts can and should take action now to help bring about greater transparency around litigation funding. Thank you.
Thank you, Professor.
Thank you very much, and I'd like to thank the organizers for inviting me. It's always an honor to come and speak in this forum. I'm going to talk a little bit about how litigation funding has morphed into law firm funding. And I want to talk about what that means and how we should assess, I don't know if I would say a growing trend may be a little strongly worded, but the emerging debate about whether states should allow law firms to seek external funding, external investment directly, which is an issue ultimately governed by Supreme Courts in most states. So what I'm going to do is I'll first start by laying out descriptively what's going on. Where do we stand nationally in terms of this trend to at least examine and maybe experiment with allowing law firms to seek funding for the law firm as an entity through some kind of an investment or ownership stake rather than through litigation funding. I'll refresh all of our recollections on what traditionally have been the pros and cons in this debate about whether this should be allowed or not. But then I want to focus on what are some new considerations for and against allowing law firms to seek outside investors and possibly sell ownership stakes in themselves. And there's new considerations that have to do with, the finance litigation products that are out there that are functionally the equivalent of law firm finance. So we're no longer discussing this in a vacuum. Is this a good idea or not? But in my opinion, is this good or bad compared to the forms of investment in law firms that are actually in fact out there? And the other big development is the way that technology, the use of remote technology is changing the legal profession in the wake of the pandemic. So very quickly, what's the state of play? I've been looking this past few days to kind of bring you the most updated survey in 3 minutes, and I thought of how to summarize what's going on. Is there a trend that's way too strong? You know, what's a better characterization? And so I would say that there's a growing cautious experimentation with innovating in the area of law firm ownership that is facing quite a bit of resistance. That's sort of how I would summarize what's happening nationally. So the big development was in Arizona, where in January 2021, it became lawful for investors to basically own a stake in a law firm, invest directly in a law firm the way you would in any other business. Arizona has accomplished this by abolishing its fee-sharing prohibition and instead saying you're going to be allowed to do this, but the entity needs to be an ABS, an alternative business structure. In a nutshell, the rules of ethics will extend to the funders as well as to the lawyers. That's how we're going to deal with the conflicts and other issues that will arise. The experiment there is off to somewhat of a slow start. There's approximately 20 firms that have decided to go the route of the ABSs. That is actually not surprising if we look globally at what's going on. There's been jurisdictions internationally that have allowed ownership, outside ownership of law firms in a limited and regulated way, predominantly the UK and Australia, for approximately 20 years. And in this jurisdiction, adoption rates are very low. Lawyers as a profession are conservative, little c, in the way that they manage their businesses. They're not, even over the course of 20 years, they're just not rushing to use this option. Have to mention DC. DC has allowed fee sharing and non-lawyer ownership on a limited basis for a very long time, predominantly to let lobbyists become partners in law firms in the jurisdiction. Again, adoption rates have not been dramatic. Utah is another innovative jurisdiction that has a regulatory sandbox that it extended from 2 years to 7 years. What this sandbox means is entities can opt out into this experiment, and they're allowed fee sharing and innovating in other ways. And the idea is, let's see what the market does in a controlled environment. As of March, there were 31 organizations that have chosen to enter the sandbox. Florida has gone in a different direction. While there has been at least an announced plan to launch a 3-year laboratory, sort of similar to the to the Utah sandbox, the Florida Bar Board of Governors in November 21 voted unanimously, voted down a proposition to try and eliminate the fee-sharing prohibition in Florida unanimously, and the Supreme Court of Florida ratified that in March of 2020. California has inched very modestly towards a little bit of experimentation. It amended its fee-sharing prohibition to allow fee sharing with nonprofit organizations that are non-lawyer owned. And we have other states that are looking to more or less extent at this development, trying to think what their views are. This includes New York, North Carolina, Connecticut, Illinois, and Georgia. By extension, other states are not looking at this. At least there's no reports that other states are even looking at it. So there's sort of a negative space. There's the states that are at least thinking and experimenting, but then there's states that aren't. So we have both of these. And the ABA came out in February 2020 with Resolution 115, where it simultaneously encouraged innovation that may increase access to justice as long as they do not involve eliminating the fee-sharing prohibition or otherwise modifying the rules. So again, I think we have a range here of anything from innovation in the Arizona style, as long as we have all the rules of ethics extended and we're being very careful, to kind of just peeking through and considering it, to saying affirmatively, no, we don't want this. Now, some pros and cons. Traditionally, the main pro in favor of this reform was that it should increase access to justice. Here I'll say, as someone who's been studying, observing litigation funding, the sibling phenomenon, for the last 15 years as it has grown in the US, we don't have data on almost anything, but observationally, it doesn't look like access to justice is being enhanced. It looks like the efficiency of law firms is being enhanced. So another way of saying it, law firms, lawyers are internalizing the economic benefits. There's no data or evidence, and I think almost anecdotally, other than in the area of entrepreneurs who are suing for IP infringement, that it's really the clients who are receiving the benefits. Now, allowing law firms to enhance their efficiencies is a good thing, right? We're in a law and economic conference, and law firms are, among other things, their businesses. So that's a benefit, but I just would want to caution that unlike other reforms that are being considered, specifically allowing non-lawyers to perform simple legal tasks like uncontested divorces, temporary restraining orders, I'm not sure that this innovation is going to help much with access to justice, which is not to say that it's a bad thing. Overall, I actually think it's a good thing, but we need to be clear on why. The counter arguments have always been this increases conflicts. We now have a lawyer with fiduciary duties to investors and to clients, and these sometimes are aligned, but sometimes conflict. It may undermine the independent judgment of lawyers, undermine the dignity of a profession as a profession, not a business, and it might wipe out the small and solo law firms. This is the Walmartization effect that is being cautioned against by many scholars in the field. What are the new pros and cons? Very, very briefly, because I know I'm running out of time. One is, again, as I said at the beginning, litigation funding has morphed into law firm funding, but in an indirect way that is less transparent and more problematic. What do I mean by that? Portfolio funding, as we've heard, coming to a law firm and saying, pool your cases together, we'll provide you some kind of a financing in return to collateral and a lien on the future proceeds that you receive, is the closest that you can get to litigation to law firm funding in the absence of just being able to outright buy equity in law firms. The other thing we're seeing increasingly is loans that include a secured interest in the personal assets of the lawyers in the firm. So basically loans with recourse sometimes and with a secured interest in the personal again, assets of the partners, which basically means loans that effectively eliminate the limited liability of the law firm as a business. Now, these developments bring all of the same problems. They increase conflicts, they increase the specter of involvement, interference with independent judgment of lawyers, but they're not transparent vis-a-vis the courts, they're not transparent vis-à-vis clients. And interestingly, and we know this based on what's being reported by journalists, oftentimes lawyers don't quite understand what they're signing. These are oftentimes they're litigators, the agreements are very convoluted, they don't quite understand that they're effectively waiving their limited liability. Sometimes the partnership signs it on behalf of the partners, so there's internally no transparency. So in that context, arguably, we're better off with having a system where in order to get financed as a law firm, which is, again, I think perfectly fine, you're a business, go ahead, but register as an ABS, have that accessible and visible to your clients, to your investors, to the courts, to defendants, and let's make sure that if you're an investor, like in Arizona, then the rules of ethics apply to you, and we've clarified, as Arizona have done, to lawyers that even if you seek outside investment, your fiduciary duties to your clients trump those to the investors. And if investors don't like it, they don't need to invest in your law firm. Finally, can I say a word about technology? I'll just make this super brief. Obviously, we all know the pandemic has introduced the use of remote technology, not just in law firms, which means that you can effectively practice law in a jurisdiction without physically being there, but courts have adopted more of use of remote technology. You can zoom into the courtroom for a lot of your pretrial procedures. What that means is that litigation funding or law firm funding is converging with technological changes to put a lot of market pressure in coming years. We're not seeing it, but that's one of the things we'll be talking about in 5 to 10 years, converging to basically make it very easy to wipe out the small firms and the solo practitioners, which are in rural America, those are your practitioners. So we may be seeing a gutting of rural America from its lawyers. And that can have significant social consequences. I'll stop there. Thank you.
Thank you. I thank you all. I feel like I need to first start and give Andrew an opportunity to rebut the position.
I always like to start with the topics on which I agree, and I have a couple. The first one, when Tripp said, on proportionality arguments, I completely agree that parties should be clear about their assets and their resources when they're making those kind of discovery requests. And so
I'm writing that down, Andrew.
and so there's a comma and a further clause. And so I would say that if a party, an otherwise lower resource party, has taken funding, the fact that they have other resources available to them through a funding arrangement should be part of that discussion. Now, I don't think that means that the party has to disclose the terms of the financing, the economic terms and other parts of it, but I don't think that you should be able to hide behind anonymity to avoid the other rules of civil procedure, for sure. I also agree with you that in questions of class certification, the fact of funding can be relevant, and in situations like those where the judge has an additional duty of oversight over the attorneys in service of the absent class members or non-lead plaintiffs. There can be opportunities there for judges to inquire about the presence of litigation funding and to confirm that a funder does not have any control or anything else untoward. And so you see in the opioids litigation, Judge Polster asked, of all the lawyers who are applying for lead positions, have you taken funding, and do they have any control? A very short questionnaire, and he reviewed those answers in camera. That is the kind of disclosure that I can get behind because it does not prejudice either party, right? And a couple of things on which I disagree a little bit. First of all, I disagree that we've never produced deal documents. In fact, there was a conference, I'm showing my age, several years ago in Georgia at Emory, where several prominent funders produced deal documents to the organizer of the conference so that she could synthesize the results into a report for members of the Civil Rules Committee, the subcommittee on MDLs that were.
Jamie Dodge.
Yeah. And so she produced a report that is part of that record, and she confirmed that there were some clauses in there that you could possibly read to sort of mean that there was sort of influence or control, but in fact, there was no express control in any of those template agreements that we produced. I was one of the folks who produced an agreement there. I disagree a little bit with the sort of question of conflicts generally, and we're doing shows of hands. Do I have any shareholders of Burford in the room, other than myself? Okay. I agree that conflicts are a real major issue. I think that any judge who buys or acquires an interest in a legal funder is making a really fraught decision given the canons of judicial ethics. You're free to do what you want, and if you do that, then absolutely have an individual rule, a standing order that says if you are funded by X funder, you must disclose that to me, so that I can recuse myself.
I think Burford was trading at $8.07 a share last week.
Y'all should buy now.
Don't talk. I certainly am not giving investment advice to this room. But those kind of focused disclosure rules, I think, are fair. I want to talk a little bit about Judge Connolly, the Chief Judge Connolly, because I think there was something actually going on there that is a fair use of his inherent judicial power. My suspicion, based on what happened afterwards, is that Chief Judge Connolly was monitoring the docket of the District of Delaware. He saw 700 plus cases filed by one lawyer on behalf of a sort of very small set of clients over 3 years, a lawyer who had not filed much in District of Delaware at all. And he said, what is going on here? And so he issued this standing order requiring all of his, anybody in front of him to disclose the fact of funding. And they did, and he pushed back on specifically this one lawyer to ask for more disclosure because he did not believe what this lawyer had disclosed to him. And then after there was a further disclosure, he asked for hearings in which that lawyer had to appear at his hearing. And when he issued that order requiring a hearing, that lawyer then voluntarily dismissed all those cases. So there was something going on there, and a judge overseeing a docket is perfectly free to say, there's something going on here, I don't know what it is, I'm going to ask questions. That's fine. What I think we object to is the sort of general, I'm going to ask every single person in front of me all the time, whether I think there's anything going on or not, just to get more information. And by the way, I'm going to hand that information that I know is sensitive and prejudicial to one party, to the other side, because they asked for it, because they want it. That's not the way our system generally works. We don't allow that kind of disclosure or discovery normally, and I don't think we should allow it here.
If we can, let's start with our questions over here. I believe we have a question.
How does it work funding the defense? I understand how it works on the plaintiffs. How does it work funding the defense?
Can you repeat that?
Okay, sorry.
The question was, I understand the funding on the plaintiff side, but how does it work funding on the defense side? Tripp or Jordan, would y'all like to address that?
I don't know. I have
Doesn't
have this much experience with that issue.
I don't know. I don't know
Maya
either.
or Andrew may.
It generally doesn't happen, right, Andrew?
It's less common for sure. And so the way that it does happen, it looks like a type of insurance, honestly, as sort of after the event insurance. What you might see, and I think the most common use would be in the context of an acquisition. A company that's being acquired has a lawsuit against it that could be a $400 million judgment against it, and the acquirer is really nervous about that. So what they'll do is they'll go to a funder to say, okay, we'll essentially pay you a premium to cover any losses or some percentage of losses between 100 and 400. It looks a lot like insurance, honestly. But that's what it would look like. It can be, though, done as part of a parcel, sort of if a large company has both defense side work and affirmative litigation, they can sort of put that all together so that the funding covers their defense costs as well as their affirmative litigation costs, so long as the affirmative litigation will be enough to pay sort of the funder's return on all of that. And that way, they're financing just that entire cost center that's their legal department.
Yes.
I know as much about this as I did about the FDA stuff. But listening to this and thinking about the other Mason conferences I've been at, I I don't fully understand the opposition of the three people closest to me. But it would seem to me that this opens capital markets or provides access to, Hank Butler's always talking about how great markets are. So this is a market, this is spreading costs, spreading risks. It would seem to be enhancing efficiency. So it seems inconsistent with the mantra that I pick up at these conferences generally. So I'm at a loss, and I need you folks to educate me on that point.
Let me say this to be clear. I'm not here saying third-party funding is terrible. It's something we shouldn't have. I was an economics major. I enjoy markets. I enjoy thinking about, access. I enjoy thinking about barriers to entry, all those things. But a completely unregulated market without any ethical duties or without any oversight at all, I think is a big mistake. I think it's a recipe for problems. Now, Andrew and Burford, they're a special organization. They are the heavy on the block they're 4 times bigger than their nearest competitor. But there are a world of privately held funders that we know zero about. And to get back to the conflicts question, I'm not glad you aren't Burford Fund shareholders. You may want to be, because it's a very successful business. But you may not know in your courtroom that there's somebody that's funding a case that's privately held with the interpersonal web of relationships all judges have. That's why I think disclosure, bringing light to what's actually happening, is a good thing. But I'm not opposed to it in principle.
Yeah, I just want to echo that and say that after 10 years of dramatic growth in this country, the empirical data that we have indicates that the U.S. litigation funding market is the largest. It began abroad, but now we've got billions upon billions of dollars that are being invested in U.S. civil litigation. And so the notion that a judge may not have a personal relationship is, I think, that's not credible. Not when we've got, all of these privately held companies, hedge funds. It used to be that everyone pretty much agreed shining some light was the best disinfectant. Sunshine is the best disinfectant. We're not here debating whether litigation funding is good or bad. I think that ship has sailed. I think litigation funding is here. It's here to stay. And what can we do to just bring about transparency? Requiring disclosure would level the playing field. Defendants' due process rights are at issue here. It's not just some investment, vehicle. We're talking about defendants' property being on the line. This country, I think you guys heard about nuclear verdicts. Just kind of making sure that the court and the defendant, know if there's an outsider that is being involved, I think is a good thing. I think we heard some news today that Burford all of a sudden supports disclosure. I think when it came to the District of New Jersey, when it came to the Northern District of California, Burford did not support those disclosure proposals, which were did not call for the disclosure of the agreements themselves. They were really, is there disclosure, is there funding happening, the identity of the funder. So, that's welcome news. I'm very encouraged by that.
Let's move to another question.
I'm not sure that, I'm a trial judge for Dallas, Texas. I'm not sure if this is the case in all states. Maybe the other judges can raise their hand. In Texas, we're required to fill out every year a personal financial statement that discloses what our assets are. I am not a Burford, I'll disclose that to the room, I'm not a Burford shareholder or anything like that. And so I don't know why that wouldn't deal with the issues that you deal with. I can't imagine most judges, I agree with Mr. Cohen, I can't imagine most judges are going to, would think it's a good idea to invest in that if they're, that's just my opinion. But do most states have that requirement that you have to do a personal financial statement? Then why do we have to do all of this?
Yeah.
Well, again, I think a big part of it is what you don't know. Burford and...
I know what I invest in.
Right, but I think you may not know about relationships with the privately held, these privately held third-party funders. You may not be aware of that at all, beyond just whether there's
Relationships in
a,
what sense?
whether there's a financial relationship or not, a personal relationship with somebody who has a stake in the outcome of a case as if they were a party to the case. I
What
think
about
that's a
defense
piece.
counsel? Defense counsel also might have a fiduciary obligation to tell his or her client if there's a relationship, if you have a personal relationship with a hedge fund person who is involved in litigation funding. I mean, the special master in the Burford back class action thought it was serious enough to say that litigation funding disclosure is imperative.
If I can just jump in here, the Burford is the easy case, but you have ad hoc investments by corporations, hedge funds, very wealthy individuals who are not litigation funders, but they are deciding to invest on an ad hoc basis for a variety of reasons, and that might be of interest.
We got another question to the right.
I'm not sure that I understand the prejudice of disclosure to the court and opposing counsel. I'm not talking about putting it on record, putting it on file, putting it for the public. I just don't understand the prejudice in the same way that we require insurance policies and coverage to be disclosed to opposing counsel.
Sure.
Could you address that?
Sure, absolutely. So I think there is a difference between insurance disclosures and disclosure of litigation finance. First of all, insurance policies are generally written before whatever is happened, and so it's sort of general liability, or there are terms of it, but you're disclosing sort of the policy and nothing else. Whereas with litigation funding, our documents have to reflect the risks of the case, and so we're not sort of handing over X million dollars on day one and say spend it as you will. It is doled out over time. There may be milestones that the parties have to meet, that the litigation has to get to before funds are released. And the return structure similarly reflects what we think the risks of the case are. Just the multiple that we get on our capital may reflect that we think something is high risk or low risk. The structure of that, when do multiples kick up, or is it an interest? Everything there is our agreements are not consumer loan agreements. They're bespoke corporate finance agreements. And so having access to that information, first of all, reveals a lot about the strategy, the mental impressions of the defense counsel, the plaintiff's counsel in most cases. And it discloses that to the defense counsel. And it sort of gives you a playbook to say, okay, well, if I run out the clock on this motion, you're going to run out of money, and then you're squeezed. Now, is that any different from the fact that I know that the insurance policy has a limit, and if the plaintiff somehow gets that exhausted, they're going to run out of money? I don't think that that's exactly the same, because when you're talking about insurance policies, you're talking about the amount of money available to pay the eventual award, if any. And so it's helpful for the plaintiff to know that there's only $20 million or whatever the amount is available, and so if you're shooting for 100, you're going to be squeezing that from a stone. On the funding side, that's not the point of the funding. It doesn't help in the decision, the settlement process in the same way. And again, I don't know how to say this any more clearly. We don't control settlement. If we do, I know that as a Burford Capital funder is not subject to ethical rules because we're not a lawyer. But I am a lawyer, and I do take ethical rules seriously. And I would find it really loathsome to misrepresent that to a court. So it's just not the same type of disclosure. If you disclose the terms of funding to the other side, you are handing them mental impressions that we don't do.
With just a few minutes remaining,
He had a follow-up, Justice.
Okay.
Just to follow up, what about that Delaware order that was in our sample? Did you address that?
Yeah, so the Delaware order, I agree that did not require the initial disclosure of the funding agreement. That's compare with the Wisconsin civil rule that does require automatic disclosure of the funding document, which is a bit extreme in my view. It only requires disclosure of the fact of funding, and then allows for further discovery if upon a showing of good cause. We haven't seen that kind of follow-up in District of New Jersey. Judge Connolly did ask for additional disclosure in some of his cases, which led to the dismissal of those cases. I think that if there were going to be disclosure required, I still think that rule goes further than it needs to. I think that there's probably somewhere less than that would be, you could, if we had to live with it, we have not seen the sort of horrible negative things come out of it that we've sometimes worried would happen. But I think that if a broad rule like that were instituted nationwide, the other side would eventually figure out how to weaponize that, because that's their job. All credit to them.
Professor Steinitz, could you address a little bit more about what you talked about, how, as I understand it, part of your theory is that this is going to allow the consolidation of plaintiff firms, the growth of plaintiff firms, because they're going to have better funding. Are you telling me that I'm going to receive more Morgan & Morgan ads on my radio? But I wish you would address that just for a moment.
Explain that a little bit. Thank you for the opportunity. So basically, the way I like to explain this to my students is there's a future in which we would be able to go to Walmart or Target, and next to the optometrist and the Starbucks booth, there'll be a law booth. By the way, I think that's a good thing. And in that law booth, you'll be able to incorporate your business for $50. You'll be able to get your uncontested divorce for $50 and so forth. That, I think, is it's a benefit to access to justice. However, it's going to come with a real cost. And the cost is that's because we are commodifying and allowing non-lawyers like Walmart or Citibank or the accounting companies that are already in the legal business to basically take over and do much more efficiently and commodify work that traditionally has been done by solo or very small firms. And so since a lot of the bread and butter of these kinds of practitioners is going to go away, then being a solo or small firm will cease to be viable. And that's going to affect predominantly rural communities.
One last question then to Tripp and Jordan maybe. We've always had law firms and lawyers be able to come together and form a joint venture or association for a particular case. The tobacco cases is a good example. So how is this different than a large group, and the tobacco cases was a large group of lawyers putting a lot of money together, and those lawyers were never disclosed. In fact, there was significant litigation by states to obtain what lawyers were getting paid how much. So how is that different than what we're talking about with third party, other than we've got hedge funds, we've got multinational companies, we now have companies like Burford listed on the stock exchange competing for the business that was previously owned by lawyers?
I'll take a crack on it, and then Jordan will improve, I'm sure, on what I've got to say. I mean, I think one thing that we're hearing from the professor all the way down to Andrew and us in between is this. We are becoming more of a business than a profession. But to answer your question, Justice Griffis, all those lawyers went to law school, were subject to the bar rules and regulations, and followed an ethical code. And we're now in an industry here in the country at this moment in time, unlike most of the rest of the world, where this industry is wholly unregulated. It's not tied to anything. There's no overseer at all. And you did have oversight with those individual lawyers because they all had ethical obligations. You don't have that today for funders.
Yeah, I mean, I don't really have anything to add. I mean, I wasn't aware of, the lawyers, banding together and kind of bankrolling the tobacco litigation, but I think that's a far cry from outsiders who are not lawyers and, who aren't subject to the ethical obligations. And I think it's great that, Burford, promises that it, does all of this, but Burford is just one of many litigation funders. I mean, the U.S. is the largest market for litigation funding. And, we do have, some egregious examples. We do have examples of control. And how are we supposed to know that those are just the outlier cases? I mean, the only people that the only entities that have the data are the funders. And so, I know we heard about, a compilation of template agreements that were submitted a few years ago, but I don't think that really, cuts it, I don't think I don't think defendants should be forced to kind of take, the, funders say so, that they don't control litigation.
We've got about a minute left, so Professor, do you want to?
I'll just jump in there and add, yes, the difference is lawyers are regulated. And also when we make the analogy to insurance, insurance is possibly the most heavily regulated, insurance and banking are arguably the most heavily regulated industries that we have in this country. Insurance have a duty to fund, they can't just bail out in the middle, they have capitalization requirements, and insurance policies are a known and understood financial product. You can get model policies, it's not a problem, we just don't have that. And just to be on the record, I am in favor of litigation funding and law firm funding. I just think I think everybody in this, on this panel, that it should be regulated because it's part of the financial industry and because it has increasingly and will have systemic effects on the civil justice system.
Andrew, one last thought. I know you're jumping for it.
Hey, regulation is fine, just has to be the right kind of regulation.
Well, I hope you will all help me and thank our presenters. Very good. Thank you. Thank you. Outstanding.